Hearing, hearing. The Court of Appeals for the First District of Texas is now in session. Pursuant to adjournment, God save the Constitution and this honorable court.
Good morning. Actually, good afternoon. Welcome to the First Court Zoom oral argument. Could the parties please make their announcement?
Good afternoon, Your Honors. Andrew Gould for the appellant Jane Doe.
Good afternoon. Marcy Rothman for the appellee Muy Pizza Houston LLC.
All right, how did you pronounce that? Muy?
Muy.
All right, we were having a discussion about that. And
good afternoon, John Jakuback on behalf of Yum and Pizza Hut.
Okay, and I understand that Jane Doe wants to reserve 4 minutes for rebuttal.
Yes, Chief Justice, that's correct.
Okay, let's begin. I do have a question for you. Are you taking the position that Rakal informed Muy managers of his intention or propensity to harm Jane Doe before the incident, and that they failed to prevent that?
Thank you, Your Honor. That is our position with respect to the adverse inference, and if I can address that more fully as I get into my argument, I'll answer that question. Good afternoon, and may it please the court. Andrew Gould for the appellant Jane Doe.
Mr. Gould, we're ready to jump into the questions rather than go through the facts. We have had a full-throated discussion of the facts, so I think we can go on to the questions and keeping with the time limits.
Yes, Your Honor. So with respect to the adverse, the answer to your question, Chief Justice Raddick, is it our position that Mr. Rochelle told his managers that of what he intended to do? Our answer to that question is yes, based on the adverse inferences that must be drawn from his selective invocation of the Fifth Amendment.
And what law requires that? What law requires us to do that?
Sure.
Tell me the name of a case.
Yes, Your Honor. So that comes from Lozano, which is a concurring opinion from the Texas Supreme Court. However, it's a controlling opinion. The portion we're relying upon has the support of 5 justices. You can find this also in Sandifer from this court, the First Court of Appeals, and also from the U.S. Supreme Court and Baxter versus Palmgiano. And in all of these cases, what they hold is that a jury may take a negative inference from a civil party's claiming of the Fifth Amendment privilege. Now, that's not to suggest that a juror is required to draw that inference. But what's important here, Your Honor, is that we are on summary judgment. Now, what Muy Pizza has said at their response brief, and this is at pages, I believe, 23 and 32, and we don't disagree with this point. So I want to make it very clear. The inference must be reasonable. And their position is that this is not a reasonable inference based on the record. And we respectfully disagree with that. And we would point to the universe of facts of circumstantial evidence that does make it a reasonable inference.
Mr. Gold, I have a question about that, because the universe of evidence that you're pointing to relate to issues other than the employer's knowledge. For example, circumstances relating to what time the defendant arrived at the apartment of the plaintiff, or what was found at the location, or what the defendant told the officer. But there is no world or universe of evidence concerning the knowledge that the employer had in connection with the inference that you're asking the trial court in this Court of Appeals to draw from the invocation of the Fifth Amendment.
Your Honor, we would point to the to Muy Pizza's actions, not just with respect to hiring and supervising, but in investigating the incident after it was reported. That is the universe of circumstantial evidence that we would point to with respect to hiring. I believe it's undisputed. That Muy Pizza did not conduct a background check as they were required to do. They did not conduct a sex offender check as they were required to do. They did not verify that he had valid auto insurance. In fact, he did not. They did not verify that his vehicle was safe for driving.
So counsel, doesn't that suggest a lack of information instead of imputing knowledge to the employer?
It goes to their carelessness, Your Honor, and why this inference in this case might be reasonable that, in fact, Muy Pizza might have known of what was going on. And again, we get beyond the hiring itself and you move into the supervisory aspect, which is that he shows up, Ms. Doe's apartment is about a 5-minute drive from the Pizza Hut location. And as our expert explained, it probably should have been a 15-minute round trip from the Pizza Hut, dropping off the pizza, returning. He's gone.
How does that answer Chief Justice Raddick's question about the information or the notice that they had prior to this alleged incident?
It goes to whether or not the inference based on Mr. Rochelle's invocation of the Fifth Amendment is reasonable under all of the circumstances. And for this, we're just relying on all of the circumstantial evidence. And then I think worst of all is what happens afterward. So after the alleged sexual assault, Ms. Doe calls the Pizza Hut location and they take a statement from Mr. Rochelle, who later changes his statement slightly to the police, but put that to the side for a moment. Muy Pizza doesn't conduct an investigation until approximately 1 month after this
Mr.
occurred.
Gold, let me just stop you there for just a moment, because I think you're going to go into what they failed to do. I think Muy concedes all of these points, right? That they didn't check beforehand. Before hiring Mr. Rochelle, they didn't conduct a criminal background investigation. They didn't conduct investigations. These are all undisputed facts. What I'm struggling with perhaps is the key question here is foreseeability. So what happened after the fact doesn't speak to the foreseeability issue. And so focusing on what they could have done, what steps they could have taken beforehand, tell me why these issues as to what happened after have any relevance to the foreseeability question before us.
Your Honor, it has to do, again, and I'm sorry if I'm a broken record, but with the question that we asked Mr. Rochelle directly, which is, what did you tell your employer, your supervisor? Because really, foreseeability is, indisputably, it is the main issue. How could they foresee that this was happening? We have to prove this. We have to prove that they knew or reasonably should have known that he was a general danger to third parties like Ms. Doe. So we asked the direct question to him, did you tell your supervisors? They respond, it sounds like it's an outlandish question. It's an outlandish question because in many respects, it's an outlandish crime. And we're trying to discover what it is that Muy Pizza knew before he left to go drop off the pizza. What did they know at that time? And so we asked him directly what it was, and he invoked the Fifth Amendment. And what we're saying is, for purposes of summary judgment, whereas all reasonable inferences must be drawn in our favor, a reasonable inference that could be drawn, even as outlandish as it may be, just because it's hard to believe it, but based on the circumstances of their undisputed failings with respect to hiring and supervising and investigating afterward, it does become a reasonable inference. Now, of course, we will have to prove this at trial. And I am not here suggesting that a juror is required to draw the negative inference.
Did
from that.
Mr. Goldnut also answer no to your direct question as to whether he had communicated directly with his employer about his alleged intentions? And his answer was no.
So he answers that later, yes, Your Honor, but we would argue that, so their section says that this I believe Muy Pizza's section argues that this eradicates our reasonable inference. And we would respond, you cannot use the Fifth Amendment shield as a sword. And that's what happened here. He invoked the Fifth Amendment when we questioned him about it. And then upon cross-examination from Muy Pizza's counsel, he's asked similar questions. And then he does answer the questions no. If anything, we argued that under cases like Denton from the Texas Supreme Court, you have to disregard his no answer to that question for purposes of summary judgment. Now, what may happen at trial is something entirely different. Maybe he'll take the stand and not invoke the Fifth Amendment. Maybe he'll invoke the Fifth Amendment to everything altogether. Maybe there will be other testimony, but here, based on the record as we have it, he invoked the Fifth Amendment with respect to our questions, and we are entitled to a reasonable inference that he did, in fact, tell his employer. Again, I understand, I sit here today and I understand that it sounds outlandish, but frankly, again, this is an outlandish crime that occurred. So again, our position is that you cannot use the Fifth Amendment shield as a sword. And so that answer must be disregarded.
Thank you. Can you talk to us about duty? Transitioning off a little bit.
Sure. And Your Honor, duty, I think duty is a much easier issue here because really there's a duty to employ somebody who is competent and fit for the job. And in this case, I think that is established by cases like Mindy M. And numerous other cases. That's just a broad-based duty. The real question, I think, really is about proximate causation. Was the alleged sexual assault foreseeable in a breach of that duty? I think in cases like COTEMP, which is our brief cites, which comes from the 14th Court of Appeals, COTEMP discusses how both duty and proximate causation are both premised on foreseeability. And I think that's right. I think ultimately this does boil down to whether it's foreseeable. And again, for that, we just pivot back to his invocation of the Fifth Amendment with respect to our question.
Mr. Gould, how do you reconcile that with the evidence that if Muy had done the background check, that no criminal records or sex offender registration information would have been discovered?
That's
Let
true.
me for just a second to say your time's running out. I want you to talk about Pizza Hut before we stop. So a quick response and then please go on to Pizza Hut.
Yes, Your Honor. Justice Guerra, very quickly then to your question. It's true that the background check wouldn't have popped it up. I would point to a case from the Minnesota Supreme Court, Ponticus, which is cited and relied upon by Mindy M, where it says failures in hiring, you have to look at all of the circumstances related to the hiring and not just the background check. And I could go into more of it, but I do want to discuss the Pizza Hut defendants. And as to the Pizza Hut defendants, genuine issues of material fact exist as to their vicarious liability for Muy Pizza's negligence. I do want to clarify our position that their negligence, of course, is premised on Muy Pizza's negligence. So if you don't find a genuine issue of material fact with respect to Muy Pizza, I will stand here and acknowledge there is no issue with respect to Pizza Hut. But with respect to Pizza Hut, assuming you do find a genuine issue of material fact as to Muy Pizza, there are genuine factual issues with respect both to control and to agents, ostensible agency. With respect to control, Fifth Club versus Ramirez, which is cited in our brief, it goes through the typical control discussion that you see in cases like Lee Lewis, which is really, and Redinger, which is there evidence of some control over the manner and methods? Here, it's related to hiring and delivery standards. And we presented abundant evidence showing that Pizza Hut employs a host of operational standards. I mean, by their own statement in their manual, they expect compliance with their, quote, exacting operational standards to maintain
Mr.
consistency.
Gold, the franchise agreement also says that MUI is supposed to set its own standards for following those minimum requirements, does it not?
It does say that, Your Honor, and we would say that that's the question here on summary judgment is whether or not there's a genuine issue of material fact as to some control. And we do think that obviously Pizza Hut can point to this to say, well, this is evidence that we don't control the standards and methods. We think that this is a factual issue, and that based on our expert in particular, Mr. Gordon, who testified that really, if you look at this manual and the standards, Pizza Hut corporate is exercising control over all the standards. That's sufficient.
Basing that expert opinion on the contract. And so when you say there's a fact issue, both your arguments and Pizza Hut's arguments and the experts' opinions are all based on the language of the franchise agreement.
And well, it is true that it's based on the franchise agreement. I think with respect to the expert, it's also based on his knowledge of the restaurant industry and how franchises and franchisors work. He talks about this during his deposition testimony. And briefly, with my remaining time, I'd like to discuss the ostensible agency issue, which is a separate way of vicarious liability. And here, what we presented is that Ms. Doe didn't know that she was ordering pizza from Muy Pizza. She thought she was ordering pizza from Pizza Hut. And indeed, the Pizza Hut delivery driver, Mr. Rochelle, he comes, he's got a Pizza Hut box. He's wearing a Pizza Hut uniform. If you look at the record, the order, I believe, is placed online. So it's through Pizza Hut's website. All of these things for her, that she is relying on their marks and picking it. And that's what makes this case like Crinkly from the Fourth Circuit that we cited in our brief. Now, Pizza Hut disagrees with the Fourth Circuit. It finds that this opinion is unpersuasive. Respectfully, we disagree. We think that it is a persuasive opinion on this point as to why, in this case, Ms. Doe did rely on Pizza Hut's holding, Muy Pizza holding themselves out as Pizza Hut to her detriment.
Were they holding themselves out as an agent, or are they merely using the brand? And how do you respond to their allegation or argument that we don't know whether that was a local advertisement or a Pizza Hut advertisement that she was responding to?
I see my time is up. If I may answer the question briefly. Your Honor, it's true that there's not evidence in the record that suggests whether or not it's a local advertisement or a national advertisement. I would simply point to, again, that when she's ordering the pizza, she's ordering it from a company that is called Pizza Hut, and the delivery driver who shows up is wearing a Pizza Hut uniform. She is relying on their marks and their branding, but she believes it is Pizza Hut. For these reasons, we ask that you reverse and remand.
Okay,
Thank you.
we'll come back. Ms. Rothman? Ms. Rothman, can you hear me?
I can.
Okay, does MUI have a duty under the law to investigate the background of its employees, specifically delivery drivers?
MUI does not have a duty under the law to investigate the background of its delivery drivers. The conduct of a delivery driver in this context is not coextensive with any foreseeable type of violence. The law is fairly clear on that. There is
so how is this case distinguishable from Scott Fetzer versus Reed, which is the vacuum cleaner manufacturer case?
Yes. Justice, there is a bright line. There's a bright line between cases involving ordinary contact with the public and cases involving special relationships or special access. Fetzer and Mindy both involve special access that is part of the job that requires somebody to enter into your inner sanctum, your home, in the case of Mindy M., your home away from home. There's a bright line between what to expect when circumstances involve vendors who are going to come to your door and how we can expect to be treated when the circumstances require somebody to enter into our inner sanctum. And so there's a substantial difference there. It's a fairly bright line. The question then becomes whether or not there is a burden associated with investigating every single vendor who might ever come to our doors. So for example, if we were going to take the appellant's position, we would specifically have to investigate your roofers, your lawn men, all kinds of things. And Nahara and Mindy and some of the other cases specifically established that kind of burden is overwhelming, and the burden itself is too weighty to overcome the utility of delivery people who, overlaying the Mindy case and the Fetzer case, do not specifically have to come into your the privacy of your home, places where you, in the case of Mindy, home away from home, where you allow your children to run free, that has private locations involved in it.
So, Ms. Rothman, did MOI have a policy of doing any kind of background checks on any employees?
MOI had not implemented a policy of doing any background checks on employees like drivers. They did have some a policy of implementing background checks for managerial personnel.
Can I just follow up on that? You said it's a bright line rule. Would you say that it's more of a factual intensive inquiry? Like we need to look at the particular type of position involved and what duties that position involves? I know that you say this is not a special relationship, but these drivers do have in some way access to a residence when they're at the threshold of a customer's door.
Well, there are a couple of ways to address that. The first one is that the law, the test here, it's a determination as a matter of law by the court. There are factual inquiries that underlie that. There are other types of analyses in the law that are similar to that. For example, Daubert motions, that sort of thing. But this is a matter of law, and it does involve factual inquiries. And so the question of whether or not somebody's job specifically requires them to go into a house is relevant. In this case, it does not. So there are so what I'd like to talk about next is the absence of negligent supervision. The court has addressed that, and Gordon admits that there is no evidence that we knew that Rachel might misbehave. Gordon, the expert, admits that there is no evidence that anything was outside the norm. And Gordon admits that the amount of time that Rachel was gone is no evidence that we knew that Rachel was going to assault the appellant. So negligent supervision also is sort of out the window. At the end of the day, going back also to the duty question, at the end of the day, there's no proximate cause. And the reason is, as Gordon concedes in his deposition on the record, that the reason is that there was nothing about the past history of Mr. Rachel that would have created notice to MOI had it done a background check.
Ms. Rothman,
Go ahead, Justice.
go ahead, Justice.
What policies do you have in place, or does MOI have in place to track its delivery drivers when they're delivering pizzas?
Yeah.
And why is this argument that they failed to track this particular delivery driver not relevant to our analysis?
So the issue in place, the policy that's in place is that they take a ticket and they establish the ticket. The computer develops the time for dispatch, the anticipated time for delivery. And the record is clear, this is an anticipated time for delivery, and then the anticipated time of return. And if the court looks at that ticket, what the court will find and the testimony of Collins Thomas, who was the assistant manager, specifically says that that ticket is an anticipated time. So if the court takes the ticket and compares the ticket here in this case, which anticipates roughly a 50-minute round trip, then what the court will find is there's about a 5-minute difference between what the appellant says was this 56-minute trip, 56-minute trip, and the 50-minute trip that the ticket anticipated. Now, the question of whether or not there was anything to track the driver after the fact is not relevant to the inquiry on whether or not we should have, appellee should have known that this gentleman was gone too long. But the reality of the record, the court doesn't need to reach that question. The reality of the record is that the ticket shows an anticipated 50-minute round trip, and there was about a 55-minute alleged trip in the face of this claim that it should have taken 5 minutes. So regardless of what the appellant says, the evidence in the record shows that the time of this trip roughly matched the time of the anticipated trip. So it's very, very close. So
And Ms. Rothman, did Mr. Rochelle continue working for Moy after this alleged incident?
he did continue working for Moy after this alleged incident, and he did briefly. That does not constitute ratification in this case. In order for it to constitute ratification, the law requires that Moy had to have known of the nature of his conduct, what he was doing, why he was doing it, and then accepted the consequences of that action. There's nothing on the record that indicates that that knowledge was available or that Moy ratified his conduct.
But did Moy do any investigation after the allegations were made?
The record does not include any investigation with the exception of talking to the police. The record does indicate talking to the police, and it also indicates that Moy knew that Rochelle was going to talk to the police and that he was talking to the police. And so that's present in the deposition testimony of Mr. Collins Thomas and also in the deposition testimony of Mr. Carlos Argueta.
Do you agree that that is a fact that we should look at in terms of deliberate indifference, in terms for the gross negligence claim?
I do not. Absent ratification, gross negligence cannot hinge upon something that does not relate to the conduct in question that allegedly caused the harm to the person claiming harm. And so I do not believe that it relates to conscious indifference with respect to whether or not gross negligence is appropriate as a result of what occurred to Ms. Deb.
So I have a question. If there's no investigation done, then isn't that a bit self-serving, because doesn't that defeat the ability for the employer to ratify the conduct?
Well, I think that's probably a question that there's nothing in the record on. The issue really, it's another issue where it could go either way. So for example, we know that the police came to the restaurant. We know that the record is clear on that. We know that the police spoke to Mr. Rochelle. We know that Mr. Argueta and Mr. Thomas knew about that, and the record is clear on that as well. And the inference, which is equally assertable, is that they assumed that the police would take care of things if there was something that was actionable. So there's no ratification, there's no proximate cause, there is no duty, because the conduct of the delivery man did not encroach upon the private spaces as a matter of his job, as a matter of what he's supposed to do in a way that society has decided is something that we are going to require the burden of a background check. I see that my time is up, but I'm happy to answer any other questions.
Okay, let's have Pizza Hut. Mr. Jack, you back? Good afternoon.
Good afternoon, Your Honor. How are you today?
I'm well, thank you.
May it please the court, John Jackieback on behalf of Pizza Hut and Yum Brands. And the plaintiff's attorney in this case, the appellant, hit the nail in that the inquiry with regard to Pizza Hut and Yum is not over once you make a determination whether or not Mr. Rashal is vicariously, or I should say Mui is vicariously liable for his acts. The question is, given the evidence before the court and given the contracts before the court, is Pizza Hut and Yum vicariously liable for the alleged acts of Mr. Rashal? And we would certainly stand by our briefs, and we would stand by all of the Texas cases that we were able to find. The truth is I was able to find no Texas case that stood for the proposition that you would violate the franchisee-franchisor relationship under the facts similar to this case, nor was I able to find a Texas case where Texas courts would apply ostensible authority to do so. And I can certainly run through those very, very briefly. But the Reddy case, I mean, obviously the seminal case is the Kahn case, and that is a Supreme Court case that stands for the proposition of whether or not there is control is based on the contracts that were in existence in this case. And in this case, there are two separate contracts that say that the employees of MUI are the employees of MUI and solely their responsibility, the brand standards and the franchise agreement. Absent some evidence that this is a sham, and the plaintiffs have provided none, absent some evidence that somehow Pizza Hut is exhibiting a level of control over and above that, the court should not violate the independent contractor principle or franchisee-franchisor relationship. The Reddy versus Domino's case is a San Antonio case that we cited. It is extremely on point in this case. It is a car accident. It's a death. And the fact is, in that particular case, had the franchisee complied with Domino's request, Domino's brand standard, Domino's requirement that they have someone check the vehicle, had they done so, there was evidence in the record that it might have made a difference in the accident. It's different than this case, but it might have made a difference in the accident. And still there, the court said no. They reversed a jury verdict against Domino's, and they said, no, this does not rise to the level of control given the fact that they have agreement. The fact that
let me ask you, the appellant cites some examples that they believe show a control, level of control beyond a normal franchise or franchisee. For example, the requirement that MUI train its employees in a certain way and implement certain training policies. Does Pizza Hut, my understanding from the briefs is that Pizza Hut monitors that level of training, requires that the trainees meet a certain grade requirement, and that you implement certain policies to make sure that you monitor and supervise the actual training of these employees. That is one example. The second example is a requirement that they implement criminal background checks on its employees, including the minimum standards that MUI has to follow when checking background checks of its employees. And the Ms. Rothman talked about how MUI doesn't have that duty, but certainly Pizza Hut requires that minimum level of obligation from its franchisors or franchisees.
Yeah, I agree. And I don't know, I can't answer to whether or not MUI believes that they have the duty or not, but I will absolutely tell you that a minimum requirement of our brand standards is that a sexual predator check be done by the franchisees. Understand in this case, this MUI is a franchisee that operates in 7 states, has 500 stores and 10,000 employees. The brand standards specifically state that how they go about doing that, whether or not they do more than that, the methodology that they use in order to set that up, and the process that they use in order to set that up is absolutely within the control of the franchisee. And it has to be that way. And that's not inconsistent with Kahn. It's not inconsistent with the Redding case. The right to perform inspections, we've cited a couple of cases, there's an Elbow case. The right or the obligation to perform an inspection does not mean that that is sufficient control such that we violate the franchisee-franchisor relationship.
This is important enough to Pizza Hut that it puts us in this franchise agreements. And I imagine that's important what does Pizza Hut do to monitor compliance with those obligations of its franchisees?
And we're talking specifically about the obligations of a check.
Correct.
Yeah, Pizza Hut does not monitor those obligations for franchisees because they couldn't do so. They have a coach, and the record will reveal that there's a coach that interacts with the franchisees, but whether or not they track that specific obligation, the answer is no, to the best of my knowledge. And truthfully, if they did, then maybe we do have a different issue of control. Maybe we would get in a situation where we're monitoring 10,000 employees and the checks that are being done. Pizza Hut thought enough of its customers, absolutely, to make that a minimum requirement, which is a lot of like what the brand standards are, which are minimum requirements that the franchisees must exercise.
So, Mr. Jakuback, what purpose does it serve if it has no teeth? What's the purpose of having that minimum requirement if there's nothing to ensure that the franchisees are doing it?
I think that's a great question. And I believe that the record will reveal if there is systemic problems with a franchisee with regard to not just this, but any obligations that they have, then there is a relationship and a discussion that has. But I will tell you that I believe that in order to impose if you impose the specific duty on Pizza Hut nationwide to monitor this specific requirement, I think that you might find yourself in a situation where there's a level of control there such that all of these employees would then be employees of Pizza Hut and they're vicariously liable. Pizza Hut made the determination to set up this franchise model. And this franchise model was set up so that Pizza Hut can have brand standards to establish continuity with regard to the quality of pizza and the brand and all of that. But this is a franchise model that has been protected by the courts of the state of Texas, starting with Con, going to Ready, and all of the lines of cases that we cited and found all stand for the proposition that simply having a requirement in there, just like there are cases out there that stand for the proposition that you can have safety requirements and take it to the level of an independent contractor in a plant. You can have plant safety policies and procedures that independent contractors have to follow, but that doesn't necessarily mean.
Following up on Justice Guerra's questions, what repercussions did MUI have as a result of failing to follow your very minimum requirements that you implement for the safety of your customers or MUI's customers?
I think that the record is, I don't know that there's anything in the record as to what happened or what discussions happened between Pizza Hut and MUI as a result of not complying with that specific brand standard requirement.
Anybody have a question?
I don't have the clock, so that I just want to make sure that we're on the.
You have 2 minutes.
Thank you, Your Honor. With regard to ostensible agency, very, very quickly, the issue is not whether or not there was a Pizza Hut advertisement that this plaintiff saw. The issue in this case under ostensible agency, and why Crinkly is both wrong and completely opposite to this case, is did Pizza Hut and Yum do something that represented to this plaintiff that Mr. Rashal was an employee of Pizza Hut? And the answer to that is nothing. This Crinkly case is a 1988, as the court is aware, North Carolina case. And the two differences about Crinkly, and it's really the sole case cited by the plaintiffs with regard to this proposition. One, there was evidence in the record in Crinkly that the brand standards were lacking. There was evidence that the brand standards were lacking. In our case, Mr. Gordon called our brand standards the gold standard. And there is no allegation that our standards weren't absolutely up to standards. And he, as I said, he called them the gold standards. And secondly, in the Crinkly case, there was evidence in that case that that there was specific, wrongdoing on the part of Domino's, and they could have taken a part in that, and they didn't. So I would rely more on the cases that we cited for ostensible agency. I would rely upon the Breeder case. I would rely upon the long line of cases, including the Cardinal Health case, which was cited by the plaintiffs. It is no different, Your Honors, than a case where Memorial Hospital says Dr. Johnson is now operating out of Memorial Hospital. That case, which is the Kimbrell case, which we cited, even under those circumstances, it does not mean that the hospital is the employer of the doctor if the doctor creates malpractice or creates an untoward act. I believe my time is up. I thank you very much for y'all's time.
Okay, thank you very much. Mr. Gould?
Thank you, Your Honors. 3 points on rebuttal, 2 with respect to Mui Pizza and 1 with respect to Pizza Hut's. First, with respect to Mui Pizza, I disagree with Mui Pizza's assertion that this is not a position that a delivery driver is not a position that allows for special access. You are unlocking the door to your home and potentially allowing somebody into the home. It is true that nobody has to actually come inside the home, potentially, but sometimes people do. Regardless, you have to open the doorway to your home and somebody can gain admission to your inner sanctum that way. I mean, after all, as you just heard from Mr. Jacobak, they have in their standard, in Pizza Hut standards, a sex offender requirement. So they understand implicitly the potential danger that can come. I'm not talking about a cook. I'm not even talking about a server at a pizza. I'm talking about somebody who's being sent to their home. The second point with respect to negligent supervision, Mui Pizza's counsel characterized a lot of Mr. Gordon's expert report, and I respectfully disagree with that, especially with respect to the supervisory point. If you look, and this is at the clerk's record supplement 375, Mr. Gordon explained that Mr. Rochelle's almost 1 hour absence should have set off, quote, alarm bells, such that he should have been contacted. So I don't think in any way his expert report or his testimony said that Mui Pizza operated with a reasonable standard of care with respect to supervising Mr. Rochelle. Quite the opposite. And finally, my third point as to Pizza Hut and control, just look at at what they say themselves. And I'm going to quote from the record, and this is at clerk's record. This is from the 846 case at 407. Both of these citations are going to be from the 846. So at page 407, system restaurants can only be operated with the necessary consistency that our customers deserve if each and every one of them complies closely with PHLLC's exacting operational standards. That's at 407. And at 301, and this is a deposition of Mr. Alford, the corporate representative for the Pizza Hut defendants, he talks about conducting audits, and the reason is, quote, to make sure they're complying with the standards, the operational standards that we have. Now, I understand that Pizza Hut is here and they're saying, well, don't rely on these statements and these documents. Just look at what we say in our franchise agreement. But the facts are different, and the facts create an issue with respect to control, such that there is a genuine issue of material fact with respect to the Pizza Hut defendants.
Gold, are those just not contractual requirements? I mean, the franchisors are going to have minimum requirements in order for a franchisee to be able to use the brand. So if they fail to comply with those obligations, you may have a breach of contract case. But how does that go above and beyond to the point that a contractual obligation is now exerting control over a franchisee?
Your Honor, it's about a level of some control. And again, during Mr. Gordon's expert testimony, or excuse me, his expert deposition, he was asked, given their robust system, Pizza Hut exhibited a level of control over the day-to-day operations of the store, particularly the hiring, training, retraining, and screening of Mr. Rochelle. This is at 348 and 49. And his answer to that question was, yes, that is his position. So it's enough control to create a genuine issue of material facts such that it should have been submitted to a jury. If the court has no further questions, we respectfully ask that you reverse and remand. Thank you for your time and consideration.
Thank you all for your arguments. This case is submitted.
Thank you.
Thank you.
Good
Thank you.
afternoon.